Afternoon. Thank you very much for coming. I can't see myself, so I hope that you can see me and hear me. Arevik and I are just going to do a short talk this afternoon. We've both had recent cases involving disputes over provision of COVID-19 vaccine, and so we thought it might be a useful topic to give a bit of seminar and to provide a bit of case law summary and have a think about how the issue might progress going forwards. We've done a short PowerPoint to go with the talk. If anyone thinks they would find it a useful frame of reference, you're all more than welcome to a copy. Either contact myself or Arevik directly, or ask Katie, who is in charge of marketing, and she can give you a copy. So, just by way of introduction, looking at the legal framework, and I should say as well that Arevik is in charge of. We've got the PowerPoint up, but only one of us could control it. So Arevik has control of PowerPoint this afternoon. Legal framework. So it's quite simple, as I'm sure you will all know. It's a best interest decision, and it's governed by Section 4 of the Mental Capacity Act. And that, of course, means that each case must turn on its own facts, but it's probably worth pointing out that in all but one of the reported cases that we'll be considering today, the court determined that it was in P's best interests to have the vaccination. I don't doubt for a moment that you're all very familiar with Section 4 and have not set it out in full. It's fairly lengthy, as you know, but in terms of the subsections of Section 4 that are of particular relevance to the issue of COVID-19 vaccine, of course, as in all cases, all relevant circumstances, subsection 2 must be taken into account. There must be an effort to ensure or promote the participation of P in every decision. Certainly, subsection 6 has been a topic of much discussion within the cases, and that is, of course, P's past, present wishes and feelings, any beliefs and values that might influence their decision if they had capacity, and any other factors that P would be likely to consider if they were able to do so. And there has been, as you will see, quite extended discussion in some cases as to P's views now and what P's decision is likely to have been had he or she been able to make a capacitous decision. Another factor or subsection of Section 4 Mental Capacity Act, which has certainly generated a lot of discussion, although it's debatable ultimately how much weight has been attached to it in decisions, are the views of others. In the majority of cases where the matter has been sufficiently disputed that it's ended up in a court decision, it hasn't been P's own objections to the vaccination that have led to the dispute, insofar as it is the objections of either P's parents, or in the case of older individuals, the objections of their adult children. So that's, of course, a whistle stop of Section 4. Arevik's just going to consider briefly the wider welfare elements of the best interest decision.
Good afternoon, everyone, and thank you for joining us. The piece of case law on the next slide, the Aintree University Hospitals NHS Foundation Trust case. The reason we cite it here is because this particular paragraph has been referred to in a number of decisions that we'll be looking at. And the reason it's so important is because it effectively sets out the key considerations that the decision makers will apply when looking at these cases. So what it tells us is that the decision makers must look at P's welfare in the widest sense, not just medical, but social and psychological. And as we go along and look at different cases, you will see that this topic of welfare in the widest sense just keeps coming up. They must consider the nature of the medical treatment in question, what it involves, and when we say what it involves in the context of COVID-19 vaccination, we're looking at the process involved. So, for example, would that process need to involve restraint, or would there be a need for sedation? And its prospects of success, they must consider what the outcome of that treatment for the patient is likely to be. So when we're looking at the outcome, again, wider considerations apply. So how the treatment would benefit P, not just in the medical sense, but for example, in the sense of being able to have access to the community and just generally wider social access. They must try and put themselves in the place of the individual patient and ask what his attitude to the treatment is or would be likely to be. Again, that takes us back to the section 4 and the wishes and feelings. And they must consult others who are looking after him or interested in his welfare, in particular for their view of what his attitude would be. Now, this is a very important point and something that will also come up in pretty much every case that we'll be looking at. When we look at the views of others, we don't just look to them for their views as to what should happen, but the court is after their views as to what P's views would be. The first case we're looking at is the case of E. So that's the first case that provides guidance on the issue of COVID-19 vaccination in the COP arena. So it's January 2021, which is more than 2 years ago now. Was it 1 year? 1 year ago now. Now, the facts of the case were that Mrs. E was in her 80s. She had a diagnosis of dementia and schizophrenia. She was a care home resident. The application itself was brought within the context of Section 21A proceedings, and the objection was raised by her son, who was skeptical about the vaccination. He wasn't considered to be an anti-vaxxer as such, so not somebody who objects as a matter of principle, but in particular, the objection was in relation to the COVID-19 vaccine. And this case is probably the only case that we'll be looking at that provides guidance on the issue of the type or quality of the capacity assessments required. On the facts of the case, the capacity assessment before the court was performed by a GP, and it was described as quite informal. The court determined that the assessment was robust enough for the purposes of Sections 2 and 3 of the Mental Capacity Act. And what the court said was that evaluating capacity on the single and entirely fact-specific issue is unlikely to be a complex or overly sophisticated process when undertaken, for example, by experienced GPs and with the assistance of family members or care staff who know P well. When looking at the issue of best interest, the court considered in particular the fact that in the past, before her diagnosis and when she had capacity, Mrs. E elected to have other vaccinations, so for example, from swine flu. So that indicated to the court that when she could make her own choice, she chose to be vaccinated in line with health advice. Now that ties with Section 4 and the issue of wishes and feelings and previous beliefs, which courts considered. She articulated a degree of trust in the medical professionals. So on the facts, when the court was looking at the capacity assessment performed by the GP, it noted that when Mrs. E was asked as to whether she would like to have the vaccine, several times she repeated, "Whatever is best for me." So that was her indication of her willingness to follow medical advice, which again was considered to be important by the court. In terms of views of others in Section 4.7, the views of her son were described as rather his own approach to life, not necessarily reflective of Mrs. E's views. And that ties with what we said about the Aintree Hospital case, where it clearly says that we look at others for not just for their views as to what should happen, but we want them to tell us what P's views would be. The court considered in particular risks to those in the care homes, high mortality rate, to the elderly, and particular risk factors to Mrs. C, the fact that she had diabetes, and there were a number of positive cases in her care home. She also lacked capacity to understand social distancing, so the professionals weren't able to look at the alternative measures as adequate measure of protection. And so the court determined that the vaccination was in her best interests. Takes me to the next case of SD. Sophie, over to you.
Yeah, I was just going to say, actually, in relation to that case of E that Ave was just talking about, I suppose there were two issues that Ave touched on that you might see as being themes, perhaps, that go through these cases as well. And one is the fact the objector has a particular concern about what's described as a speedy authorization of vaccination, but then says, well, I'm not an anti-vaxxer, but I'm not comfortable with the speed. And there are different judicial nuances of dealing with that particular concern. And the second matter that Ave touched on, which is, I think, is interesting and might be something where there's scope for there to be a further case, is the fact that in none of the cases a capacity either been an issue or really been explored in the capacity to make the decision to have the vaccine or not has been an issue or been explored in any detail. So similar issues are arising in SD, which is the second of the cases that came before the courts, or certainly was reported, and that again is a case before Hayden from February of last year. And in SD, V was age 70. She had a course-cost diagnosis. She is significantly overweight, and she resides at a specialist care home. And of course, each of those factors puts her at higher risk of serious consequences should she contract COVID-19. SD, who was her or is her adult daughter, sought a declaration that it would not be lawful or be contrary to V's best interest to administer that vaccine, or in fact any other vaccine, and that application was opposed by the local authority. SD attended the hearing by video link as she resides in America. A couple of slightly unusual factors that were considered in the course of the judgment. One was that the care home had been quite extraordinarily effective at preventing COVID from entering the home. In that case, they hadn't had a single reported case. Again, capacity was not an issue. The court heard in the course of its decision oral evidence from the social worker, the support worker, and SD herself. The court didn't hear any medical evidence, though of course had written evidence from clinicians. Hayden held that the risk matrix that applied in RE applied the same force in SD, and that of particular weight was the fact that V is in a high risk group, that she lives in a care home, that it is impossible for her to follow the principles of social distancing and preventative hygiene measures, and it wasn't feasible for her to self-isolate. If she contracted COVID-19, she was described as being very sociable and a wanderer. Also of significance was the fact that V herself was very compliant in following professional advice. Part of SD's evidence was that V, when she'd been capacitous or was somewhat circumspect, and would have been circumspect about accepting the vaccine. But it was recorded that she had accepted the vaccine in the past with no resistance, that when asked she hadn't been and wasn't anxious about this vaccine. Again, SD, a particular concern of SD's was said to be a concern about the swiftness of the vaccine rollout, that she felt that there should have been a greater focus and research onto the impact of the vaccine on patients with dementia. Of some pertinence was the fact that every other resident and every staff member in that care home had been vaccinated by that point. And that's something of a double-edged sword in some ways. It was given weight by Hayden because it meant that there was going to be greater contact with the outside world, and therefore that would put V, in this case, at greater risk of contracting COVID-19. Conversely, of course, the fact that every other resident and staff member had been vaccinated put V herself within the care home at less risk of contracting the condition. So whilst SD said that one of her particular concerns was the swift nature of the vaccine rollout, she also, in quite lengthy evidence, included reference to the possibility of experimental alternative treatment, so ivermectin, which is the anti-parasitic drug that's originally a veterinary drug, which certainly hasn't gone through the testing process, and which I think Hayden was somewhat sceptical about even considering. And what the court said and made clear, as Arve has touched on, is that SD's views are not those of V, and this is not the function of the Court of Protection to arbitrate medical controversy or provide a forum for ventilating speculative theories. And Hayden said in cases such as this, there is a strong draw towards vaccination as likely to be in the best interests of a protected party, and it was determined that it was in V's best interest in that case to have the vaccination.
The next case we'll be looking at is the case of CR, heard by His Honour Judge Butler. So we're now on to March 2021. It's a few months after the case of E. The facts were different in this one. So first notable difference is P's age. So CR was in his early 30s. He had a severe learning disability, autism and epilepsy. He was living in a care home, although his residence arrangements were described as temporary. So he was there for assessment. He was described as clinically vulnerable rather than clinically extremely vulnerable, and also described as significantly overweight, also placing him at higher risk. His father was objecting to the vaccination taking place. He cited CR's health issues and just the general concerns about the safety of the vaccine in view of the lack of testing, he said. It was interesting that one of the issues that the court referred to was that CR's concerns were also expressed in relation to MMR vaccine. So he believed effectively that the fact that his son was administered MMR vaccine when he was little caused him to develop autism, and as a consequence, CR had no other vaccines since then. Now, again, capacity wasn't an issue, and it was really the issue of best interest that was considered. The court said that, well, it wasn't possible to ascertain P's views because his ability to communicate was compromised. But the court said, well, there are no contraindications for the use of this vaccine, which would apply to CR, which was a relevant consideration when determining best interest. The court considered the fact that there was a high percentage of deaths in the care homes as important, even though CR's own care home was COVID-free at the time. CR was unable to comply with social distancing and hygiene measures, which appears to be a persistent theme and an ongoing consideration in all of these cases, or the majority of them. And he expressed no anxiety in relation to medical intervention, which is directly relevant to the issue of the process. So when we looked at the Aintree Hospital case, we said that the process that needs to be followed is relevant, or whether the process would require, for example, restraint or sedation. The side effects of the vaccine were described as mild. The physical intervention wasn't authorized. And the court specifically referred to Article 2 of the European Convention of Human Rights and said that the consequences of the infection are such that presumption in favor of preserving life must be applied and steps taken to prolong it. And the evidence before the court, those steps were effectively in authorizing vaccine as being in P's best interests.
Thanks. And there's a question, I noticed a question just while Ave was speaking, I think arising out of the previous case, the SD case, which is where the physical restraint was authorised. Now, I haven't had a chance to cross-check back, but certainly when Arve and I were discussing it, I think our reading of all of the reported cases was that in none of them did the court authorise physical restraint in giving the vaccine. And I think in one or two of them, the court said explicitly that the matter would have to return to court if it was proposed that any physical restraint would be required. So I don't think there's been any authorisation of physical restraint. In terms of chemical restraint, I think there has been reference to PRN in a couple of them as part of a care plan, but certainly not explicit authorisation of any sort of restraint. I'm sure Arve will correct me if I've got that wrong. SS. So SS is another Hayden case, this time from April of last year. It is the only one of the reported cases where the court determined that it was not in P's best interest to have the vaccine. SS was aged 86. She has a dementia diagnosis. She resides in a care home. So far, so similar as the other reported cases. This had ongoing Section 21A proceedings. It was not a standalone application. SS has no close living family or close friends. She has a cousin who provided some evidence. By way of context, as a result of SS's dementia, she to some degree lives in something of a fantasy world. She worked for many years as a secretary at the Lions Cake Factory in Chiswick, and at 4 p.m. every day she will grab her handbag and her jacket, and she goes to leave home to go home to her parents. And that's something that has apparently been ongoing at the time of the hearing for some years. So SS had refused the vaccination. In fact, she was strongly resistant to any medical intervention. And it was thought that if the vaccine were to be given to her, then it would be likely that physical restriction would be required. At the care home where SS resides, there had been a very high number of deaths. There have been 99 residents, and 27 of those residents had died of COVID-19. There was a review of S's medical records, and within that, revealingly, the records went back as far as 1997 in terms of records of vaccination, and there was no record of vaccine at all. There was no flu vaccine, and there what was described as being a clear pattern of refusal. Hayden considered that had she been offered the vaccine whilst capacitous, it is likely that SS would have denied it. It was also of some relevance to the decision, the factors to be weighed up, that SS was someone who was naturally inclined to keep her distance from others. So she's perhaps at less risk of infection than someone who was very gregarious or kept in close proximity to other people. Of some note is the fact that all the other residents at the placement had been vaccinated, but some staff had not. And so the biggest risk to SS was from staff coming in, having interacted with those outside who with COVID and potentially having contracted COVID. There was a requirement on staff to have a lateral flow test before coming to work, and that was thought to present some protective element to SS. Of course, if the matter were decided today, the picture might be, and the evidential picture might be slightly different, because of course the government appear to be now looking to phase out LFTs, which will presumably potentially put SS at greater risk from unvaccinated staff members than before. And of course, as you'll be aware, the government has also rolled back on the requirement for NHS staff and care home staff to be vaccinated. And so again, there's not that obligation that there was a few months ago. So in determining the best interest question, Hayden said that it quite clearly, based on the medical evidence, it was in P's best interest to have the vaccine. However, the determination of best interest requires evaluation in the very broader sense of welfare, the entry point, as it were, and it requires the decision maker to put themselves in the place of the individual concerned. In this case, very heavy weight was attached to the fact that SS had previously declined vaccines. There was a proposal by SS' cousin that it might assist in persuading her to have the vaccine if she was told that her father would want her to have the vaccine. Of course, her father was deceased, but it was a method that had been used by him in persuading her to do other more minor matters. And Hayden roundly rejected that as being unethical. It was also an important fact that it was thought that restraint or sedation in the involved carers would be needed, and that would damage the relationship between P and her carers, with whom she was very close, and undermine that trust. That would be very detrimental to her. Ultimately, Hayden determined that it wasn't in her best interest to have the vaccination. And in a moment, I think Arve is going to talk about a case called AD, where in some there were some similarities, but where a different decision was reached. And I don't doubt that it was in the mind of the court, and it may have even been ventilated in the course of argument. But one factor that isn't overtly considered in the judgment that does come to the fore in AD is the potential consequences, the double-edged consequences of P being resistant to medical intervention. I mean, on the one hand, it suggests that she might well have been averse to the vaccine had she been capacitous, and that force would be required to administer it. But perhaps longer-term potential consideration of that, which doesn't appear in the judgment, is the fact that if P does contract COVID and have significant consequences from that, it's more likely to be difficult and distressing for her or him to then be treated and receive medical intervention. But I'll let Arve address you on AD.
Just on the point of SS, Sophie, and the point that you've touched upon, as to the proposal that was made by the cousin to effectively deceive SS into undergoing the vaccination process, it also would tie in with the entry point. So we again end up looking at the process, and the court saying that, well, I think the court explicitly referred to it as deception, and said that this would not promote her autonomy. So even though the court no doubt appreciated the risks involved, the court wasn't prepared to follow that specific process. In terms of AD, so AD was in his 30s, living in supported living placement. The diagnosis he had was of moderate learning disability, Down syndrome, and autism. He was described as significantly overweight and clinically extremely vulnerable. The application was brought by the CCG. It was for the first and the second dose of the vaccine, as well as the booster. The courts agreed that the first and the second dose were in his best interest, but not the booster. And I'll come to discuss the reasons for that in a moment. The complexity of this case was in the fact that AD was reluctant to engage in any medical interventions, which effectively led to two considerations. Well, one, there would be a possible need for restraint or sedation to administer the vaccine. And two, if he did contract COVID-19, he wouldn't engage in the medical interventions needed to treat him. He was described as a sociable person, as somebody who likes to access the community, but unable to comply with social distancing or wear PPE. So, for example, he would want to approach somebody in the community or just access the community, but wouldn't wear a mask. His mother disagreed with the proposed vaccinations, whilst the professionals and his father supported it. And the reasoning relied by his mother was essentially the issues around trauma to him, the distress that would be caused, the allergy concerns, and overall beliefs into the dangerousness of the vaccine. In terms of the booster not being authorized, the idea behind the court's reasoning, and my reading of it, is effectively this, that we all have a choice to uptake the booster as and when we need to. And when we do that, we have the benefit of the up-to-date information and advice. So we benefit from it, and so should P. So there was no need to have this declaration so far in advance, because the circumstances may well change and the information and advice may also change. So this was one of the cases where chemical restraint was authorized. I think it was described as mild, but not physical restraint, which brings us to the case of DC, heard by His Honor Judge Burroughs.
Thank you. This is a recent one from January of this year, and there's some really, I think there's some really interesting discussion in this judgment, and also a really nice summary of the law as well, which is very helpful if a case comes up. So in CCG and DC, DC was aged 20. He had serious physical and mental disabilities and health issues. Of note was the fact that although he was aged 20, he actually weighed very little. He weighed no more than a small child, and this was a particular concern of his mother, who was very concerned about his fragility and the fact that whilst DC is a clinically vulnerable adult and therefore eligible to and eligible to have the vaccine and recommended to have the vaccine, in fact, in physical terms, in some ways, he was a similar size to a small child who, at that point, there was no recommendation to have the vaccine, and what she felt no available research into any potential contraindication to that. Father's concerns largely related to the safety of the vaccine and research he'd done into that. Of the issues that came up in the case, one issue which is worth noting is the fact there was some delay in bringing the application. There was quite significant judicial criticism of that. Judge Burroughs said that it was apparent in February 2021 that there was an issue over this, but the application was not issued until December 2021, and then he ensured that it was brought before himself within a month of that. Judge Burroughs was very focused on the need to act speedily if P is vulnerable to the virus, and that clearly hadn't happened in that case. Again, capacity wasn't an issue in DC. What there were at the outset of the case were quite a number of applications made generally by the parents for additional expert evidence, effectively to fine-tune the risk and benefit analysis of the CCG's evidence. All of those applications were refused. Again, Judge Burroughs was very focused on the need to have this matter heard and on the urgency of it. Although he said he during the course of the hearing, he bore in mind the possibility that he might require further expert evidence, and eventually determined that he didn't. It is possible, I suppose, in the future, depending on how the ongoing vaccine rollout goes and any research that's done as to impact of the vaccine, any negative effects, that it might be that there might be a place for expert evidence or additional expert evidence, but there hasn't been that in these applications so far. There's a very interesting discussion, Judge Burroughs, I recommend you read, that it's a wider application, I think, as well, but it's about sitting in P's shoes and how important it is for the court to do that and how one goes about doing that, and particularly in the context of vaccination and COVID vaccination in particular. There's consideration of how P might, if capacitus, be influenced by altruism. about the fact that having the vaccination as a capacitous adult, it is arguably being a responsible citizen, that you do it as much for other people as you do it for yourself, your other people in wider society. Another interesting point that's touched on and considered in this judgment is the importance of the context in which the decision is sought, and that I think is a really interesting point, and needs to be borne in mind in applications going forward, given the changing nature, or the ever-changing nature, of the national picture insofar as COVID is concerned. Of course, when the first reported decision was made at the start of 2021, we were in lockdown again. We were in the third lockdown. We were at a point where tens of thousands of people had died from COVID, especially in care homes and other care settings. We were at a point where vaccination and the vaccination programme was in its infancy. Of course, the context of DC was quite different. Things had moved on. In fact, I think the decision was made the week before the lifting of pretty much all COVID restrictions, rather than interpreting that as meaning that the risks have now lessened and COVID is perhaps over. We're perhaps being encouraged to treat it as having been now. The judge appeared to consider, in fact, that meant making this decision was more pressing and more urgent, rather than less, that the lifting of restrictions meant that DC, as an unvaccinated and vulnerable individual, was at greater risk than ever. Another quite interesting, I think, element of the judgment in this case was Judge Burroughs' consideration and sort of nuanced views on this concept of the truncation of testing. You will have noticed in all the reported cases, there is this theme in objections raised by family members, the concerns about the fact that the vaccine has been rushed through, that it might not be safe, that it's not been thoroughly tested. And that's been, I think, given relatively short shrift by most judges, given that it's gone through the approval mechanisms. I don't say that critically of the judges who've made those comments. In fact, Judge Burroughs' approach was, I think, a little different. Ultimately, reaches the same conclusion. But he accepted on its face the test. He said the testing of the vaccine has been truncated, and why it doesn't follow that it is unsafe. But it has certainly given him pause for thought in making the decision. I think relatedly, there have been, again, within a number of cases where the relative has said, amongst other things, well, not yet for the vaccine, rather than not at all. And again, the judge in this case tackles that issue head on. He says being clinically vulnerable makes this urgent, and an urgent decision has to be made if you're in a high-risk category. Clinically vulnerable people do not have the luxury of time. In thinking about what P himself would have done had he been capacitous and the influences there may have been of him, I think an interesting case, a difficulty in this case, and probably in other cases for judges to grapple with, is the fact that neither P's parents or his sister had accepted the vaccination. They were all unvaccinated, and of course your family is likely to exert really significant influence on you. So it's arguable that perhaps P would have been less likely than some others to have accepted the vaccine, but the judge considered overall it was more likely than not that P would have made a decision to have the vaccine if he could do. A feature which doesn't feature so heavily in other cases is the fact that Judge Burroughs found that a magnetic factor for DC in this case would be that his enjoyment of life would be increased if he had the vaccine. He would be more able to take part as a young man in activities at his placement, in life at his placement, and also doing things with his parents. So in this case, of course, which is I think 7 months after the case that Arevik has just discussed, and of course the discussion about the booster was again in its early stages. The full course of vaccinations was authorised. There was no physical restraint, although there was no physical restraint authorised as well. A useful or interesting case that Judge Burrows noted and found helpful was McDonald J and M&H and PT, which is an MMR case. And in that case, McDonald J looked at REH, which said in the Court of Appeal, which said the court must be guided by public health and the Green Book, and said in those circumstances, in the context of MMR, of course, McDonald J found it very difficult to foresee a case in which a vaccination approved for use in children, including vaccinations against the coronavirus that causes COVID-19, would not be endorsed by the court as being in the child's best interest, absent a credible development in medical science or peer-reviewed research evidence indicating a significant concern for the efficacy and or safety of the vaccine, or a well-evidenced medical contraindication specific to the subject child. Judge Burrows found it difficult to see how a similar logic didn't apply in case of COVID-19 vaccine, and that's likely to be powerfully persuasive to other judges who have to consider the issue as well. I can see a question's come up, but it's quite a long question. I'll have to look at it in a moment. Arve and I were just going to briefly talk about some cases that we've had recently where the issue of vaccine has arisen. My own case from last month was a slightly different factual background, but one which may arise more frequently given what's happening with COVID. P in that case was in her 20s, had a moderate learning disability and autistic spectrum disorder. P didn't reside in a care home or care setting, or she's right in the care setting in a care home like the individuals in the above cases, but if she was in hospital, and she was in hospital fit for discharge, and she had been fit for discharge for many months. She was in fact being accommodated on the elder care ward to try and reduce her risk of COVID vaccine, but she was ready for discharge, and whilst it wasn't the only factor, a significant factor preventing discharge was her unvaccinated status. And I couldn't really see, and you who are at this talk may know better than I, but I couldn't see realistically what proportion of placements, care settings, including daycare settings, require vaccination now, and how that might impact on decisions such as this. But certainly in the area where the local authority were looking for placements for P in this case, they were finding it profoundly difficult to find anywhere that didn't require P to have the vaccine. P's mother objected in this case. She had vaccine concerns about the vaccine, and again, and similarly to, I think it was a case of AD, where P had ASD, she had real concerns that arose from the MMR vaccine, and what she perceived was a reaction of P after the vaccine and a connection between the vaccine and P's ongoing difficulties. And of course, then it's tangential to this issue, but it does show the real and lasting impact of the discredited study on the MMR vaccine and how that's impacted parents who are in difficult situations anyway. Mum was very frightened, and really when it was drilled down, she wanted the court to make, she didn't want to make the decision, she wanted the court to make the decision because she felt responsible, understandably felt responsible. The hospital doctor in that case gave quite detailed oral evidence, very helpful oral evidence to the court, and ultimately the court determined that it was in P's best interest to have the vaccine. And of course, the additional factors that were borne in mind, as well as the risk matrix set out in the other cases, which may be worth bearing in mind, of course, is that in hospital, P was at exceptionally high risk of infection and exceptionally high risk of COVID-19. And there were a high number of COVID patients in the hospital. The doctor gave quite interesting evidence that I hadn't heard before, albeit it was anecdotal, and it was accepted to be anecdotal evidence that as someone who dealt with people with cognitive difficulties, older people with dementia, he anecdotally had observed what he perceived to be a greater instance of effectively long COVID, of evidence of long-term delirium, which he felt was very distressing to them. And I think the judge weighed that fairly heavily in the balance. Again, and similarly to the more recent cases that are reported, the course of vaccines is authorised, but physical restraint was not authorised, albeit that P had a PRN available as part of her care plan already. I don't know if that in fact has any similarities to Arev's recent case.
It does, and I think the circumstances were not dissimilar to the case of AD, as you say, in my case as well. There was a parental objection. There was dispute between the parents as to what should happen. The local authority and the CCG were both parties, and so that the CCG were providing sort of the medical perspective. Interestingly, the issue of MMR also cropped up, and beliefs surrounding that vaccine. But effectively, the outcome was very similar in that the orders were granted, so the best interest declaration was made. The physical restraint wasn't authorized, and in fact, as I recall, we had a certain number of attempts that were to be tried, and if there was no engagement, then the attempts were to be abandoned. So the court wasn't prepared to entertain any prospect of any kind of restraint, being that chemical restraint or physical restraint at all. On the slide now is reference to JCVI statement on COVID vaccinations. And effectively what we can pick up from that is that the vaccinations are likely to be relevant and around for the foreseeable future. It is difficult to say how many cases there will be in courts in relation to this, but it is likely that just like we can see the court's considerations evolve and change since re-eve, they will continue to do so. And as restrictions in the society change, the attitudes change, and so may the views of the professionals in relation to the vaccination. Sophie, anything further on the JCVI statement?
No, I've seen a query from Charlotte Greenwell. I hope she doesn't mind if I just run through it. So we currently represent P in Section 21A, MCA. We use care and residence. He's clinically extremely vulnerable. All professionals involved in his care, all involved in his care, agree he should receive the vaccine. His wishes and feelings are difficult to ascertain. Best interest decision was made that his best interest be the vaccine. However, there have now been 3 failed attempts to administer the vaccine due to P not allowing a professional to administer it, with physical aggression shown from P. Based on the webinar, it appears to me the court will need to consider the facts of the case on an individual basis and give permission for any restraint sedation. In your opinion, is this the correct approach? I mean, to me, and I'm happy for anyone to chip in, but certainly that does seem like it would have to be the correct approach. It'd have to be, I think, quite a detailed potential plan for restraint and a weighing up of the in a best interest basis of the impact of using that restraint on P negative to make a determination and have that very clearly authorised by the court, I would think. Do you agree, Arve? Does anyone else have a particular view on it?
I don't know whether anyone else can express their views or whether
silent, maybe just in the chat box.
But no, that I agree. Yes, that sounds right. I'm still sharing the screen, and I'm on the last slide, which has our emails. And Sophie and I would like to invite you to get in touch with any questions that you have in relation to the seminar, or if you have suggestions as to the future seminars, the topics you would like to hear about. So please do get in touch.
Yeah, we were talking about feedback to our direct email addresses, but I mean, that'd be kind in feedback. But yeah, if you've got any questions or anything you want to discuss, any comments, then just email either of us. That's absolutely fine. And as I mentioned at the outset, if you think the handout would be at all useful at all, then don't hesitate either to ask either of us or ask Katie, and she can circulate a copy to you. But thank you very much for attending. And I hope to see you soon. Take care.